when you're in the planning stage, and we're directing this predominantly to musicians or to music estates, the most important thing is to identify what does the person who wants to create the plan, what do they own? Are they just a performer? Were they a singer? Are they a producer? You're seeing a lot of estates areas with the hip hop artists where a lot of them started as producers. And under the new Music Modernization Act, there's more rights being recognized for producers. So it's really important to identify who is the person that wants to create their estate. And then the most important asset, if you can identify it, is a copyright. And it's important to understand that the copyright, there's two different statutes involved. The length of copyright is very long, whether it's a 70-year or a 95 plus life. You're dealing with...
Correction, life plus 70?
Life plus 70.
Or
95 from the date. Sorry, but that's Michael's specialty, so he's going to interrupt me, and I'm going to hopefully interrupt him.
She's testing me. I'm listening.
But the bottom line is it's really a valuable asset. Copyrights, I think, are underrated, especially in an older catalog. Our catalog is heavily driven by television. It was until we sold just last May. It's not a year yet. But we had some standards. They were in a lot of sync, a lot of television shows. So it's owning the copyright and identifying whether or not you retain the publishing. Before I go into too much more detail, the question is, how many of you know copyright, music copyright, or just a raise of hands, how many do music copyright as included in part of their practice? Okay, and how many don't know what a copyright is? Okay, then I'm going to just pass over it. The one thing I am going to say is, as you're identifying who your client is, to understand that with the bundle of rights that are given to a copyright owner, those rights are separated up and are frequently transferred to different companies, maybe inside the US, outside the US. And I brought an example of the old-fashioned print right, which is one of the exclusive rights. This book is current. So there's works of my father's in here that were written in the 60s and 70s. So this is just one example of where your music will show up. A lot of these lyrics and songs are now on the internet. Another example is the right to make a derivative work. So my father wrote Holiday for Strings, and his publisher at the time had the right to have a derivative work made, which was basically lyrics. So those are the different rights that might be split up, and it's very possible that the person who comes into your office, maybe they're a print publisher, or maybe they were a business manager for an artist or a songwriter, and all they have is an income stream. And there's a lot of different rights associated with that.
Angela, if I could just jump in, I just wanted to spend a few more seconds on it because all of these rights come from the Copyright Act itself. So when you were talking about something like the right to publicly perform a copyrighted work, well, that's why ASCAP and BMI and the other CSAC and GMO have the right to collect substantial performance royalties. When you talk about the right to reproduce a composition, and the writer and the publisher get royalties, that's a mechanical royalty. And we are living in an age that is changing daily as far as the sources of income and the magnitude of the incomes, because in the case of sound recordings, the right to publicly perform now includes, under the Digital Millennium Copyright Act, it included the right to collect royalties from the Pandoras and the Sirius Radio providers. All the digital transmission services on a non-interactive basis now are paying a lot of money for the performance of recordings. And Angela mentioned the Music Modernization Act. Who here represents legacy acts? Well, the legacy acts, as many of you know, now are getting a piece of that pie, because under the Music Modernization Act, the older sound recordings now are generating that type of royalty. And as Angela said, if you represent a producer who produced a recording, you get a piece of that pie too. So you have to think, where are the royalty streams coming from, and how do I want to address it in the estate plan?
And along that line, and I'm really just bringing up issues or topics so we can get to them some more meat, but I don't mean the beef, but I mean Michael's talk. Sorry. But it's also identifying, is it a musician? Was he a member of the LA Phil, and he was a violinist, and he performed on a lot of studio work? So maybe he's been a musician in a score for, let's say, a Batman movie or something. There's rights that go with that. A lot of those rights can be designated in advance to go to the heirs. A lot of those things can be registered after the fact. But there's a lot of rights that are related to people that touch in the music industry. So if you get a musician that comes in your office, or they mention the word music, or they say, well, I sometimes get a royalty or a statement from Harry Fox. Who is he? Or what's ASCAP? What's BMI? And it alerts you that there's something to be done. Included in our materials, and you can find a lot of it online as well, is the fact that ASCAP, BMI, I couldn't print them up from CSAC, and I don't know about Global Management or Global Music Rights, but a lot of them have beneficiary designation forms. You can sometimes make your beneficiary designations in advance. Sometimes you can do it after the fact. Just cursory points. A few more little points before we get to Michael. Clarify precise ownership issues. Have there been multiple marriages? Have there been copyrights that were written during the course of the first marriage and not transferred to the, they maybe were transferred to a third party and they're not being collected as part of the second marriage. And you also have to check the number of kids and who are lawful heirs. Practical considerations, which Michael's going to get into in a lot more depth, is how do you hold certain assets? But most importantly is if your client or the person you're representing had a publishing company and you have the opportunity in advance of their death to discuss a plan with them, it is really important in family-held businesses that one heir who's been working for the company the whole time maybe has an employment agreement or there's some provision made in the will for the continuation of management of the asset, because when there's a lot of kids and it's time to share in music publishing assets or in income, they all want their share and they disregard the one family member who knew everything that was going on, who's a key to it. And I did have an employment contract at the time that my mother passed away, and the estate was, my father had died 25 years before. My mom, exactly on the 25th year, pretty much died. And we had a plan in place, and it moved very smoothly.
And if you think about it, it's not too different than any other family business where perhaps the father started the business and maybe one or two of the children work in the business, but 3 or 4 don't work into the business. And I'm sure all of the estate planners in this audience advise their clients on succession planning and who's going to control the business, who's going to be a passive participant. Think of it that way.
And Michael's going to get a lot more comprehensive on termination and how to hold a business. But the one point I want to mention is that termination rights, which are rights that belong to the author or to the author's heirs, are really very valuable rights. And a lot of people don't understand terminations, and it's a complicated system. So you do want to you want to consult with somebody. If you think there might be termination rights, you need to anticipate them before the plan is done, and then you want to be prepared to refer the family to someone else to make sure they're done. But there's a lot of related issues.